Okay, so I see the numbers increasing. I've started the recording, and I'll start with introducing Mr. Raman Sagar, our speaker for the day. Thanks, Aman, for joining us today. And for his introduction, Mr. Raman Sagar, he's a trainee at RSR Legal Advocates, and it is an IP boutique firm which is based in Noida, India. And he has completed his law degree, his integrated bachelor's of arts and law, a degree from Central University of South Bihar in Gaya. And he is a graduate. He completed his law degree in 2020, and he specializes in intellectual property rights law. And since then, he has been associated with RSR Legal Advocates, where currently he is a trainee associate. So his scope of work, it encompasses a broad range of services in trademarks, in which his core specialization is. And he also advises on domestic and international clients on issues relating to clearance search, trademark prosecution, and post-registration matters, including assignments and renewals. He also handles and manages overseas trademark portfolios for Indian clients in other countries. And apart from trademark prosecution, he's also involved in trademark and copyright litigations in the firms. So that's Mr. Raman who is with us. And over to you, Mr. Raman, and thanks a lot for joining again.
Thank you, Ms. Sania, for this brief introduction. I'm really grateful for this invitation. So just hold on for a second. Let me share my screen with you all. So are you able to see my screen?
It is still loading, Aman.
Just a second.
No
So
issues.
I am in one of the most worstly affected cyclone areas. So it will take some time. Please cooperate.
Yeah, Aman would want me to share your PPT on this end, if that helps.
Just a second. Give me 30 more seconds to
Yeah,
try.
sure. No worries.
Just a second. Is it working now?
Not coming, Aman. Still.
Okay, so I'll share the screen from my end and please let
Yeah,
me
thank you,
know.
Sunil.
Yeah. I hope the screen is visible.
Yes, ma'am.
Just a second, my device is having some problem, I guess. Not Yeah.
Yeah.
Yes.
Is it
Yes.
fine? Mm-hmm.
Yes. Yes.
Okay, so is the screen visible to everyone?
No, ma'am. PPT is.
Just a second. Just hold one second. Yeah, is it visible now?
Now it's. Yeah.
Okay. Okay. Yeah, Aman, please tell me when to move to the next slide, and I'll help you with that.
Can you please move on to the second slide?
Yeah, sure. Yes. So does it work fine?
Yes.
Yeah.
This
Okay.
is going well. So I'm really apologetic about what is happening with my device, but that's okay. That's fine. Thank you so much for bearing with me. So as the topic suggests, introduction to trademarks, in today's proceedings, we'll be discussing about the historical developments of trademarks in India, of course. And moving further, we'll come to know what exactly is a trademark, and based on the strengths of trademark, how to adopt a trademark, use a trademark, and we'll also discuss in detail about the procedure of registration of trademarks in India, along with the opposition details, and what are the benefits of a registration of trademark in India, along with the civil remedies available with the registration as well as the criminal remedies that we have in Indian trademark law regime. So coming further to the next slide, that is the historical developments. So can we move on to the next slide, please?
Yeah, I have moved to the next slide.
Yes, yes. So the history of trademark dates back to the 16th century, and it has its origin from the British colony. So it all started with the impression that a certain origin as to the manufacturing or the production of good were traced. So in that scenario, that gave the origin to the common law rights of passing off. The impression was that you cannot pass on the goods of one trader on the impression that it is originating from you. So it started from there. Moving further to the advent of Industrial Revolution in 1885, the British Parliament enacted the Trademarks Act of 1885. Based on that premise, since India was a colony to Britishers, so Indian merchandise marks was passed in India as well. This act was not very comprehensive, and it provided for the registration mechanism, though this was an unprecedented step, but it had some limitation because it provided for the registration of limited number of marks for, say, words and symbols, that's all. So it had to be eradicated. These other transactions related to trademarks, such as the licensing, the third party usage, was not present in this act. So India also had one legislation, the Indian Registration Act of 1908. So that was used to register the licenses, agreements, and other assignment transactions related to trademarks. As now we have other legislations as well. So in 1935, again, a requirement was felt that the trademark law needs to be revisited. So in 1935, British Parliament again enacted the Trademarks Act of 1935 in United Kingdom, in UK. So again, based on that, the Indian 1940s Act was enacted. Again, this act was not very comprehensive. And since India got its freedom in 1947, so India wanted to work on its economy. So it again enacted the Act of 1958. So this was a masterpiece legislation because it provided for license, assignment agreements, third-party usages. In fact, the concept of prior use was also instilled in this act. So if I would like to let you know that India is a country which discusses and protects the priority users. So if I say, if a mark is being used since 1999 in US, and in 2021, somebody, that proprietor of course, wants to register its trademark in India in 2021. So based on its priority rights, he or she will get his registration as prior user. So again, in 1995, we had a TRIPS agreement. So that TRIPS agreement provided for the minimum standards for protection of trademarks. Based on that, there had to be made various changes. So the legislature felt that in spite of amending the earlier act, it is better to enact another act. So Trademarks Act, it is a brilliant legislation. It provided for number of marks, which we'll discuss in the due course of presentation. So can we move to the next slide, please? Yes. So now the question arises as to what exactly is a trademark. So trademark is an identifier. In a layman's language, it identifies the origin of a product or a service, that from where, which manufacturer or producer or service provider is providing certain services or products to the consumers at large. So as the name, as our name distinguishes ourselves from another, in the same way, trademark distinguishes the source of a product or a service. So if you can see, these are few trademarks: the Audi, Rolex, Giorgio Armani, Samsung, Apple. So these are the trademarks which distinguish and represent a quality that these brands wear. Now, again, a small clarification is required with respect to the trademark and brand name. So there is a very thin line difference between brand name and trademark. So the first one being that the trademark is a name which is used in legal parlance, while the brand name is used in marketing. It's a marketing terminology. So in marketing, professionals use that. But a brand name can have various trademarks. Let's say Nestle. Nestle is a company, Nestle India. So it has various brands such as Nescafe, Maggie, of course. So for example, Maggie. So when we say Maggie, so Maggie is a brand, and that brand can have a number of trademark registration. The first, the Maggie word as a word mark. Second, the logo of Maggie, of again a device mark. The slogan, the packaging, the trade dress. So this is the difference between brand and trademark. A brand can have many trademarks, but this is how it goes. So now we'll move on to understand what is the statutory definition of a trademark. So how the Trademarks Act, Indian Trademarks Act defines a trademark. Next slide, please. So section 21ZB. So it defines what is a trademark. So it says trademark is a mark which is capable of being represented graphically, and it is able to distinguish goods of one trader from another trader. So now the question arises, what is a mark? So the mark, the definition of mark is provided in the section 21M of the Trademarks Act, which says a mark can be a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging design, combination of colors, or any combination of those. Now, one of the most important things is to be considered from this definition is that the graphical representation requirement. So why the mark needs to be represented graphically? I see it as a twofold explanation. So the first one is that the trademark which are registered has to be entered upon the trademark registry register. So in case the registry wants to see a mark at any given point of time, it can just look through the register and see that this is mark X, register in the name of Y. So this is how it works in first fold. The second fold is that suppose I want to register a mark which is deceptively similar to the Apple's logo. So, and I try to pass on the goods of Apple in my name. So how would Apple know that I am using that mark for identical services or goods? So for easing that reference, the graphical representation requirement is necessary, that you present your goods so that the public would know that whether you are infringing upon their rights or not. So this is how it works. And the other important element is distinctiveness. If your mark is not distinctive enough to distinguish its good or service from other, it is not liable to protection, because it can cause confusion. And the whole trademark law regime is based on protecting the rights of a proprietor as well as the general public from the confusion. So this is how the definition of trademark works in registration process, first of all. Later on, we see in the next slide, we see what exactly are these marks. So if you can see in this slide, a device. So when you see the device M, I am sure that everybody will understand that this is the logo of McDonald's, and McDonald's are famous for their burgers. So this is the reputation that this logo has generated. Again, we can protect the word mark as Apple has protected its word mark. The letter RF, it stands for Roger Federer. So Roger Federer, it was registered in the name of Nike, but the rights of this mark are being transferred to Roger Federer because the collaboration between the sporting icon and the sporting goods manufacturer giant has ended. Again, the next one goes is brand. Like I said, the Maggie. Maggie is a brand name. Again, the Indian Trademark Act also protects the signature. So this is a signature of a very famous photographer, Piyush Bedi. So it's a registered trademark. So whenever he clicks a picture, this mark is instilled in all his pictures. Now we have the color combination. So color combination is a very typical mark. It has it's somewhat controversial because the distinctiveness requirement is very difficult to prove in these types of mark. So if you see, this is a green paint, green background on which yellow stripe passes through the mark. So this is a mark, color mark, which is protected in the name of John Deere. They are the automobile, mainly tractor manufacturers. So the slogan, we also protect slogan, just like McD's, I'm loving it. Nike's, just do it. Moving further, we have the numeral. I'm not sure if you guys know about one 555 matches mark. So again, we have 8 p.m. as well. Sound mark. Sound mark is again difficult to be proven with respect to their distinctiveness, that whether they are inherently distinctive or not. In 2007, yeah, right, 7 or 6, Yahoo got its first registration in India for a sound mark for its yodel. Very recently, Netflix has also received its registration for its intro sound. I'm sure many of you would be aware about that sound because it starts with that sound only. Again, we have label marks, shape marks, the bottle of Coca-Cola, the name marks, and any combination. So this is the combination CR7. It stands for Cristiano Ronaldo, and the number 7 is his jersey number. So that is a protected trademark under class 25 in India. So moving further, there are some other marks as well, which we consider as non-traditional marks. Non-traditional in the sense that they are not inherently distinctive, that their distinctiveness can be acquired. They are not distinctive since they are adopted. Like we have sound mark, like I said, smell mark, motion mark. Very recently, Tesla has received registration for its motion for door openings of its cars. Again, we have taste marks, single color marks as well. So if we have seen the Cadbury chocolates, it always comes in purple color. It's a single color mark that is protected in European Union as well. But Cadbury is a name which has acquired enormous reputation and goodwill among the customers. So that can be proven before the court of law. Now, why the trademark is necessary, what function does it promote, is to be interpreted so that one can offer registration of a trademark. So trademark has mainly 3 functions. The first one is, like I said in the very beginning, it identifies the source from where the mark is being originated for what goods. The second one being that it denotes the quality, that what quality that mark bears. Like we say, when we say that Apple is famous for mainly computers and mobile devices. So it denotes a quality that if the Apple computers are manufacturing the mobile, definitely they are going to provide the best services. So this is the quality that gets associated with a trademark. Third one, that is the most promising one. It acts as your advertisement is instrument. It provides an impression to the consumers that this mark belongs to Apple, or this mark belongs to Nestle, or this mark belongs to Audi, Benz, whatsoever. So now comes the question of adoption of mark. How do you adopt a mark? So we adopt a mark based on the strength. So history suggests that the mark have always been adopted based on the strength. So if we understand the hierarchy, the first one is fanciful or coin marks. Can we move on to the fanciful slide, please? So that this is the fanciful or coin marks. These are the marks which are invented. They could not, cannot be found in the dictionary. That means they do not have any meaning, but they have been generated through innovation and creativity. So these are fanciful marks. For example, Kodak, Nikon, which are these marks are used for cameras and photography. So these are coin marks. They were never in the dictionary. They do not bear any meaning. Like again, Zomato, Swiggy for food delivery services. They also do not find their presence in dictionary. Another one is, so these are the strongest marks. These are liable for strongest protection. The second one is arbitrary marks. So the arbitrary marks, as the name suggests, they do not bear, they are existing words, but they do not bear any relation to the goods they are attached to. For example, Starbucks coffee. So Starbucks is an existing word, but when I use it with coffee, it do not bear any meaning, or it does not provide any meaning to the mark itself. So this is the arbitrary mark. Again, it has a strong degree of protection, like we can also see in the case of Apple. So Apple is a fruit and it is being used for computer devices, no relation. So these are strong marks. Moving further, we have suggestive marks. So these marks are words which suggest some qualities but do not describe the mark itself. For say Airbus, so Airbus for airliners, Netflix for streaming services. So there is an impression that it is used for internet services, but it is not descriptive per se. That is why they are, though they are not the strongest mark to for protection, but they are liable to protection. Again, the question might arise regarding the acquired distinctiveness, whether the mark is something which public associate with it with some exclusive proprietor. For say Netflix, it suggests, but Netflix is solely associated with online streaming services. Moving further, we have a weaker section of marks, which is descriptive marks. So prima facie, these are prohibited marks. You cannot get registration for these descriptive marks under the Trademarks Act of India, because these are marks which provide the description either in the form of kind, quality, geographical origin, anything. So these marks are not protected unless and until they state that it has acquired enormous supermarket. So this, although the bazaar is a generic word and that bazaar is big, so it provides for a quality. It describes the mark, but again, like I said, it has acquired a reputation. It has acquired a secondary meaning among the consumer. That is why it can be protected. Again, we have Your China. So Your China till 2011 was considered as a suggestive mark. It got its registration, but in 2011, it was refused protection by Madras High Court. It was held to be a descriptive mark for restaurant services on the premise that it provides something, some quality description with respect to the type of food being provided in that mark. So I would say now the next mark is the generic mark, the weakest mark. So these are not liable for protection per se. These are marks which have become goods in itself. For say Xerox. So Xerox was a trademark, but it was used so exclusively with the photocopies that it became the product itself. So it became genericized. It became publicized juris. That is to say, it is the word which is used very commonly in the trade. So if you use the stationery, we all know what is Xerox. So generic marks are not liable for protection, but there is an exception. In the year 2011, Wix is a company we all know, Wix Vaporub. So Wix Vaporub filed for the application for registration of its mark. The court, the trademark registry refused the registration. So it challenged, it appealed against the decision of the registry, and the court held that though it is a generic mark, but it has acquired a secondary meaning in the eyes of the consumers. That is why they are liable for protection. And in this way, that mark was granted protection for, of course, pharma products. Moving further, we have the most strong mark, which is known as the well-known marks. So these are marks which has acquired a reputation that it can never be used with something else. It is such marks. So when I say Bata, we all get an impression that Bata is something related to footwears. When we say Bisleri, we understand that Bisleri is a mark which is used for beverages, mainly packaged mineral water bottles. We have Bajaj for electricals, Omega for watches, Philips for electrical goods, Benz. So Benz was a mark which was protected on the basis of trans-border reputation in 1993 by the Delhi High Court. So these are the examples of well-known marks. So well-known marks are beyond their class of goods. For say, if Bata has been registered or granted the protection of well-known mark for footwear, like for say under class 25 goods. So it cannot be used for any other goods as well, because it may cause the dilution of the brand value which Bata has generated since its long and extensive use. So which is why the R Act protects the well-known mark beyond the class of goods. And the reason being that the substantial segment of public associate that mark with separate mark or separate proprietor only. So now we will understand what is the process of getting trademark registration in India. So we are clear with the adoption part. So we always advise as to what kind of trademarks to be adopted. So when a client comes to you, he'll come with certain set of marks which he believes that these are the last options, these are the most preferable options that he would like to go with. But as a trademark attorney, you always have a challenge. You always have a challenge to work in the interest of client. For say, you have to get registration for your client, but you also have to see that the proposed mark is not infringing upon the rights of other trademarks or proprietors. So the first step comes the availability search, that you try to find out whether the mark which is proposed is being used anywhere in India or in the world. Well, for say, because India also accept the notion of trans-border reputation as in Whirlpool case in 1996. So based on that premise, we need to understand whether the mark is in use globally. Once the mark is clear to adopt, we have to provide an opinion. We make the client understand that if we need to adopt that mark, it might have challenges such as third-party oppositions or litigations. But this can happen only when the client comes to you with a mark which is deceptively similar. Suppose our client comes to you with an invented worm. So in that case, the chances of protection becomes very high. So once the search availability is done, we file an application. We move on to second step. That is, we file an application. In India, the trademark application can be filed on proposed to be used basis, that I intend to use the mark in future. I'm not using it currently, but I want to use it in future. And or I have been using that mark since X date, but now I want to get protection via registration. So why such marks are filed on a late basis? Suppose I started using a mark in 2010 and I filed registration for that mark in 2021. So we do that to provide acquired distinctiveness, that for the last 10 years, I have been using that mark and the mark has sufficiently become associated with us only. Like for say, if you want to get registration for a generic mark, I'll give you a very recent example which has happened, the Clubhouse app, which has gained enormous reputation. So Clubhouse, if you see the mark itself, it is descriptive. It's Clubhouse. It gives you an impression that it is a club where we are going to discuss. Needless to say, it is a platform which asks people to gather and discuss. So it is a generic mark, or you can say a descriptive mark. So prima facie, these are not liable for protection in India. So what the proprietor does, it do not opt for registration initially. It starts using the mark, and when the mark gains huge reputation, based on those evidences, it files for registration, because the chances of getting the registration for that mark increases manifold. So if you see, Clubhouse was valued at $100 million in 2020, but now the valuation of that app has become $4 billion within a year. So this is how the generic words are used for protection, and this is so on. This is how it goes. So coming to that application, so we file an application in Form TMA, and the cost is 4,500 rupees for individuals or sole proprietors, and for others it's 9,000 rupees. So when we file an application, the mark is proceeded for examination. So in the examination, if the mark is objected, you have to respond to that examination report. Otherwise, if the mark is accepted, the mark will be advertised. So once the mark is advertised, a third party who thinks that your proposed mark is not distinctive or something which is infringing upon their rights, so it can oppose your mark. But the trademark registry opposes your registration as per section 9 and 11. So section 9 talks about the absolute grounds for refusal of trademark. The first one I already talked about is the non-distinctiveness. If your mark is not able to distinguish then it is not liable for protection. But if your mark, like in the case of Clubhouse, has acquired distinctiveness, it will proceed for registration. So this is how it works. The absolute grounds and the relative ground. So relative grounds are grounds. So all these absolute grounds I have already discussed. So the relative grounds, if your mark, which is deceptively similar to an existing or prior mark, on that ground also registry can oppose your mark. So in that uh, objection, you need to respond as to why your mark should proceed to registration. There can be chances that your mark is entirely distinct, but the registry has objected to your mark. So that can be overcome based on the circumstances of cases. So moving further to the opposition case, once your mark is advertised, are there any chances that whether your mark can be opposed by any third party who have prior rights in those marks? So yes, the answer is simply yes. They can be opposed. So opposition can be filed as per section 21. So it starts with filing a notice of opposition, which can be filed by any third party who has an interest in that mark. That is to say, either they are the proprietors, they are the licensed users, they are the assignees of the trademark. So in these forms, these become the interested party to file a notice of opposition. So once a notice of opposition is filed, and that notice of opposition has to be filed within 4 months of the date of advertisement. So when the NOP is filed, the applicant is served upon with the NOP, and that applicant has to reply in the form of counter statement as to why your mark should proceed to registration and how that mark is not infringing upon the opponent's mark. So once these processes are done, again the stage of evidence comes. So we need to file evidence by way of affidavit that these are the evidence on which we are relying to support our or substantiate our contentions. So these happen within the span of 2 months. Now, if the registry is satisfied, it can reserve the order or pass order in the favor of the opponent or the applicant. But if the registry or the registrar is not satisfied, a hearing is appointed to hear the arguments of the contesting parties. And based on that, decision is given. So now we have to, since the opposition is, I guess, clear. So now we need to understand what are the benefits, what are the exact benefits of getting a trademark registration. So like I said in the very beginning, that trademarks by way of passing off are always protected. They have been getting protection since 16th century. But what trademark does is, trademark facilitates the goodwill aspect, that when you get a trademark registration, it guards your goodwill. It guards your goodwill that, see, passing of action is a very costly affair, no doubt, but it's also a tedious affair as well, because it is based on the tort of misrepresentation. So you will have to make the court understand and prove that certain proprietor has misrepresented your goods in the way that it has caused damage to your goodwill. But when your trademark is registered, you only need to prove that the certain trademark is similar to you or identical to you, nothing else. So this is the right. You get the rights by way of registration. It guards your commercial goodwill. It cuts your costs on litigation as well, of course. And like I said, it identifies your origin. It assists you in civil and criminal enforcement. And it acts as a valid proof before the MCA. So why MCA and domain name? So one thing I would like to mention is that Domain names are also registered as trademarks. For example, www.bookmyshow.com. It's a registered trademark. So these are the trademarks that can get registration based on earlier usages. Like in the MCA, you get registration for trademark. You can also use it as a trade name, your company name. And if your trading name or the company name is being used by any other, that is deemed to be an infringement as per section 29(5) of the Trademarks Act. So you can also restrict somebody else from infringing upon the rights guaranteed by way of your trade name or company name. And the foremost and the one of the valuable assets of a trademark is that once you want to sell off your business, the valuation of trademark decides the valuation of sale of that business. For example, like I mentioned, that the RF trademark is being transferred from Nike to Roger Federer. So it is $1 million settlement because it had acquired a distinctiveness exclusively to the sporting icon Roger Federer. So the value which Nike has generated by use of that RF has resulted in getting huge amount of monetary outcome by way of sale back to Roger Federer. So I think all it's clear now. What are the civil remedies that we get by way of trademark registration? So always we can file for trademark infringement suits. We can also file for passing of suits. We can file for interim injunction. We can file for John Doe order. So John Doe orders, I'll briefly touch upon John Doe. So John Doe is the name used for somebody who is unknown. For say, if your mark X is being used on a website called Y, but you don't know the proprietor, the owner, or the rights of that website. So what will you do? How will you serve upon that proprietor, website owner? So in that case, the cases are instituted in the name of John Doe. So John Doe stands for male. And when there is a female, if you assume so, it becomes John Dane. So where the defendants are unknown, we file case in the name of X versus John Doe, X versus John Dane. This is how it works. So these are very prevalent in website cases. So again, we have criminal remedies. So the distinction between civil and criminal remedies is about what we require. So we file civil suits to get damages, to claim damages. But when we advance upon criminal aspect of trademarks, so we file an FIR before the local police station or the judicial magistrate that certain proprietor is infringing upon your mark by way of falsification. So two terms, the falsification of trademarks and the falsification and the infringement. So these are two sides of the same coin. The one is civil action, the second one being criminal action. So if you are disturbing, if you are tampering with the trademark by way of making a trademark which is identically or deceptively similar, you are falsifying a trademark. So falsification also means that you are using a deceptively similar mark or identical mark for your goods, your any use of that mark in the form of a trademark. That is falsification. So these are the civil and criminal remedies and the distinction between the enforcement strategies of trademark. We also have broader border protection measures, like we can write to the border custom authorities that we have an apprehension that certain goods bearing our trademark, that is, of course, that is not our trademark, that is a false trademark which is identical to our mark. So based on that, custom authorities take cognizance of those of your request and notice and seize those goods. So we have custom protection rules. These work in trademarks, patents, as well as trademark cases. So this is all we have with regard to the introduction of trademarks. So now we can move ahead with the questions, and I can see we have few questions as well. So
Yeah, I see we have a couple of questions in the chat box as well.
yeah, right. So
Hello, Aman.
yeah, Siddharth, I'll get back to you while. Just let me see the first question, please.
Okay.
Miss Sania, can you please let me know about the first question, please?
Yeah. So the first question is from Ishani, and she asks, please suggest some best methods to do trademark search by common people and by lawyers or professionals.
That is a very good question, because once you are not clear with this question, you are not going to advise your client in a better position. So ideally, we have 3 searches, right? Am I audible?
Yes, yes.
Yes. So ideally, we do 3 searches. The first one being the trademark registry, that is IP India, that is a trademark public search. And the second one being the Google search, to know if our proposed mark or the client's proposed mark is being used in relation to the services or goods which he proposes to use, or in relation to some other goods as well. So this is how we know on the basis of a Google search. The third one is the MCA search, in order to protect the interests of our client so that he does not infringe upon the rights in the trade name or company name of other proprietors. So these are 3 searches. Apart from 3 searches, we do domain name search to understand if the proposed mark forms to be a part of a domain name as well or not. So now these are the searches, but how to do the searches is the tedious question. So even when I was a student, I too had this doubt that how to uh, find those marks which are present in the trademark register. So it is difficult. See, the law firms and big lawyers use some softwares. So there are some softwares which they use to find what are identical or similar marks. But as a common layman or a common lawyer or common person, you have a very limited access, because the registry website provides you with a limited access to a database. For example, if I say that Maggie, so when I use the word Maggie and you go onto IP India website, trademark search, you type the word Maggie and you type the class 29, that is for uh, food products. So you'll find that there are marks which contain the word Maggie, but you'll not find all the marks, the device mark, the logo mark, you'll not find all the marks. So these are the limitations which we face while doing the search. So to tackle that problem, we rely on some softwares, and Google works best, because on Google, you'll come to know what are the possibilities of mark being used in other jurisdiction and in relation to other services or goods. That's all.
Thank you so much, Aman, for that clarification to Ishani's question. I do see in the chat box we have some comments from Pavan. I guess he's also trying to answer Ishani's question, and we would like to know your views upon what Mr. Aman has shared. So he says, just simply type trademark search India in Chrome, click on one link shown in Chrome, that is IP India Online, and there you can search your trademark according to your need, either word mark, Vienna code, or phonetic. And he further goes on to say that phonetic sounds, which sound similar for a particular word or phrase. And he asks in this, how can we then protect the interest of the client in a better way. So he's asking the question regarding to phonetic sounds in which the sounds are similar for a particular word or phrase. So in this, how can we protect the interest of the client in a better way?
See, like I said, there is a limitation to find all the marks which are deceptively or identically similar to your client's mark. So it's a challenge. So you are relying on IP India. That is true. That is the best because that is the registry's website. That is the most important database which you need to understand and go through. The second is, like I said, like I mentioned throughout my presentation, that there are marks which are not initially opted for registration, but they are in use. They are in commercial use. So for knowing that, you'll have to rely on Google and other softwares. So phonetically similar marks, again, the remedy goes to relying on the searches, the similar searches that we do via Google or via software. There is no way out to this because phonetic marks are difficult to search even on IP India website. And moving to the Vienna codification. So Vienna codification works on certain set of codes. So if you are not aware about the codes, so it has codes for textile goods. Even on the textile goods, they have codes for shirts, designs, everything. So they have classes of codes, and based on those codes, you have to search for codes, search for identical or similar marks. So this is a tedious process as well as time-taking process. So in order to safeguard the interest of client, so you can advise him in a way that if you find a mark which is being used for similar services, so it is better not to proceed with the registration, because if you become his agent, instead of being an attorney, you just become his filing agent and you say that yes, there are prospects of success, and you file. So what are the challenges? The first is the trademark registry objection. Second one is the third party opposition, and the worst of all, civil suits for passing off or infringement. So better to save the interest of client in terms of time as well as hard-earned money. It would be advisable not to proceed with any mark which has very less success rate. I guess I'm clear to his question.
Thank you so much, Mr. Aman, for that clarification to Pawan's question. We have another question from Mr. Siddharth Pandey, who asks, which is better protected, descriptive or suggestive mark?
It's simple. Suggestive mark, of course, because they are not, see, suggestive marks are something between all the marks, that they are not either very weak and they are not either or very strong. So they are in between of all the marks. They are not inherently descriptive, neither they are inherently descriptive, nor they are inherently what should I say, distinctive. So in that case, the best option is to relinquish, I would say. If your client says, see what happened in the case of your China. So the registry stated that this is a suggestive mark. It is a strong mark, it can be protected, and it was granted protection. But what did the court do? The court refused the protection. That no, it is providing a relation or description as to the services or the type of services being provided. So prima facie suggestive marks are stronger in comparison to descriptive mark, but I would say it should be avoided from registration prima facie. But if you do not have any option, you can go for it. You can work for the interest of the client. Initially, like we all do, the trademark practice is, as I stated in the case of Clubhouse, we start using the mark. We want the mark to acquire a reputation among the public, and then after we can proceed for the registration based on that evident. So this is how it works. I hope, Siddharth, I'm clear.
Thank you so much, Aman, for that clarification. We have another question from Mr. Kushal Mishra, and he asks, Sachin Ramesh Tendulkar is a trademarked name. Therefore, we can't use this name without Sachin's permission. Sir, is the field for this name is limited to movies, or is there any other place where we can't use it?
See, the trademark law is very clear about the usage of mark. So if you have applied mark for, say, any marks for, say, like you said, Sachin Ramesh Tendulkar. So Sachin Ramesh Tendulkar is not only a mark registered in India, his signature is also a registered trademark in India, along with his initials. So that mark is registered in terms of specific goods. So you cannot, in fact, Mr. Sachin cannot restrict other proprietors if the same is being used for other goods, provided that Mr. Sachin is able to prove before the registry that this mark is solely something which public associate with me exclusively. So there can be chances of opposition, no doubt about that, but the chances of success depends on the facts of the case, to which goods it is being used. So it can be opposed. There can be third-party litigation if we want to use it for other marks, other goods.
Thank you so much, Aman. I see we have a very interesting question from Ishani. So she asks, sir, please comment your views on the Coronil case where Patanjali has been fined 10 lakh rupees by the Madras High Court when the Coronil is in use but in different class. So your views on the Coronil case.
Yeah, thank you, Ishani. I do not wish to comment, but as you have asked, I would say two things for sure. The first thing is to understand the basis of trademarks law, firstly in India as well as globally. So the basis of trademark law is the public interest. Why a proprietor is restricted from using a trademark which is being used by another. So this is the public interest aspect, that the public will get confused as to which is the one which they considered it to be. So in case of Coronel, so again the public interest aspect came into effect. The thing was that we had a pandemic with the COVID-19, and it was known, it is still known as Corona times and Corona. So this was something which could have caused confusion among the minds of the people. So what Patanjali did was, I'm not truly aware about the facts of the case, but I have read the judgment briefly. I know about it very briefly, but I know about the underlying rationale behind that judgment. It is the public interest aspect that the public will get confused as to cure Corona, you can use the Coronil. So Patanjali takes a defense that no, we did not ask anybody to skip the vaccination, but it is something which is for you, which will act as an immunity booster. So this is how Patanjali defended its claim. So coming about the penalty aspect, 10 lakh fine. I would rather say 10 lakh is a hefty fine for sure. But how do courts take it? So very recently, Juhi Chawla was also fined, maybe 20 or 25 lakhs. So I guess judiciary is not taking all the matters on equal front, because had there been somebody else, would the court fine 10 lakh or 20 lakh? I'm afraid not. It is the reason being that those corporates or those companies or those personality be a huge reputation among the consumers. They act as influencers. Even Patanjali gets its product in every household on the basis of nationalism, made in India project. So that is fine. That is whole another debate. I'm not getting into all of that. So the fine, I'm not satisfied. This is what I believe, because although the adoption of coronel was not justified, because it is liable to cause confusion. And another interesting aspect of trademark law is that it is not based on causing confusion. It's based on likelihood of confusion. Even if there is a chance of confusion, you are restricted to use such mark. You need not prove the actual confusion. Thanks, Ishani. I hope I'm clear. And please do not mind my views on this case.
I had a question from my side, Aman. So as you told,
Please.
In cases in which there is a slight chance, specifically in some situations where it might be directly linked to a person's health, for example, in this case, coronal, people thought that it's something that if we take that dose, we'll be free from corona. They used to take the medicine and then didn't put on mask and things like that. So would you think it directly, would you think that with such reasoning, this hefty fine could be justified because it has a direct impact on health? And you can say it's one of our basic rights as well, right to life, right to our health. So do you think in that sense we could justify this hefty fine for confusing people?
I would not differ from your view, because at certain point of time, you are affirmative with this right to health aspect. Because in this, for the last 1.5 years, we have been badly impacted with this COVID-19 situation. So the court also took the cognizance of this havoc that has been created by this pandemic. And based on that, it fined 10 lakh rupees. So although 10 lakh rupees is not a big amount for this Patanjali, because it has been providing a lot of goods and it has a huge consumer base in India. So yes, you are right. Based on that consumer base only, the court might be of opinion that since you have a national presence, there might be a chance that public will get confused as to the application of coronal with respect to the treatment of COVID. So can be a possibility. Yeah, right, true.
Thank you, Aman. So we have a very good question from Harshit. He asks, sir, please comment your views on the recent news about Facebook's WhatsApp breaching Europe's GDPR, where Facebook was fined for breaking the EU data privacy policy.
See, this question is way out of the topic, but that's okay. One thing we must understand, that in this technology time, the biggest challenge we are facing and we are going to face is our digital privacy concerns. So this was highlighted way back in 2011 by Edward Snowden. This was so these tech giants, let's say Facebook, Google, or any other tech giants, they have been breaching the policies, privacy policies. They give you click wrap agreement. If you accept it, you are able to use the services. If you don't, gates closed. That is very simple. So coming on to the GDPR aspect, it is an amazing piece of legislation. It provides for the data limitation aspect, purpose limitation aspect. It provides how you can safeguard, what responsibilities as a data processor as in the one who collects or processes data. So what are the duties and liabilities you have? All these things have explicitly been provided in the GDPR. I hope and I am very optimistic about our Personal Data Protection Act, which is still tabled in the Parliament. So I believe that that act will also be a mirror of that GDPR. Coming to your question, the breaches. So this is not the first time it has happened. Do you remember the Cambridge Analytica? It was also something which Facebook did. So it helped to shape and perceive the views of common people in America, to cast the votes in favor of Mr. Donald Trump. So these tech giants have been doing all of these. They try to search for the loopholes, lacunas in your legislation, and they'll attack you there. We need to be ready. The recent issue regarding Twitter, they were reluctant not to appoint their grievance officer. Recently, they have shifted some of the officer who was responsible for all those managerial decisions to US. So this is how these corporate work. They evade their responsibility. They are breaching your privacy. It is you who have to safeguard your digital footprint. If you are using anything, nothing is hidden. As simple as that. If you want to save it, incognito will not do any better.
Thank you so much, Aman, for that clarification, and also taking up a question for data privacy, which is kind of another very broad topic, a very distinct but a very broad topic as well. So we have a question from Advocate Saurabh Arora. He asks, would sub-brands be entitled to goodwill and reputation established by the main brand?
I'm not too sure about this aspect, although the question is very nice, but I cannot be too sure because see, if we see Nestle, see for example, I have two brands, sub-brands of Nestle. The first one is the Nescafe. The second one is Maggi. So if we take these examples, we can answer the question in affirmative that yes, Maggi has acquired a secondary meaning at least among the student class of people. So every student or every household knows the name of Maggi. Even the coffee, the Nescafe, it has acquired its another kind of goodwill in the market. So in short, it will depend on facts and circumstances of each and every cases. It's not a straight jacket fit for all, one fit for all formula. It can happen in some cases, but it cannot work in other cases. So it depends what kind of strategy those companies or those proprietors take. So if you know about Nestle, so Nestle about 75,000 trademark registrations all over the world. So this is their trademark portfolio. So this is how they protect and enforce their trademark. So if their sub-brands is not going to acquire goodwill, then whose brand will?
Thank you, Aman, for that clarification. I hope that answered Advocate's question. We have another question from Pavan. So he asks, sir, in Pepsi Kurkure case, the John Doe order, the Ashok Kumar order was passed. But still there are some videos which states that it contains plastics, etc., or other things. How can we protect our client's interest in this case?
See, to be very honest, I'm not aware of this case. But coming to the question, if it can be elaborated in a different way, I might be able to answer it because I'm not aware about the facts of the cases.
Pavan, if you would want to unmute yourself, because you also had another question which you wanted to ask regarding internship. So if you could unmute yourself and then interact with Aman directly. Yeah, Pavan, please go ahead.
Yeah.
Hello. Good afternoon, everyone.
Yeah, good afternoon, Pavan.
Sir, in this case, ये हुआ था कि जॉन डे ऑर्डर पास किया था कोर्ट ने कि पेप्सी का जो कुरकुरे उसके अंदर प्लास्टिक उन्होंने कुछ बोलता है कि हमारे अंदर एक पर्टिकुलर सोल्ट है जिसकी वजह से ये बर्न जब होता है तो ये काला हो जाता है, जिसकी वजह से जॉन डे ऑर्डर पास हुआ था कि जितनी भी वीडियोस आपको सारी हटानी है, क्योंकि सारे पोस्टोमस में भी आ जाता है कि आपका पोस्टोमस है, ये पता नहीं लगता किसने कहाँ पब्लिश कर रखा है। बट हुआ क्या था, अगर आज भी हम सर्च करते हैं कहीं किसी भी प्लेटफॉर्म, चाहे यूट्यूब हो चाहे कहीं कहीं पे भी हो, प्लास्टिक कुरकुरे, बट देयर आर स्टिल मैनी वीडियोस। तो अगर ऐसा हमारा कोई क्लाइंट का केस आता है तो हम वहां पे कैसे प्रोटेक्ट कर सकते हैं इस चीज को कि
See,
ये
this is a
वीडियोस अभी भी है?
I mean, it is an area which needs proper attention. So you're right. The court orders are not enforced in toto. So yesterday what happened, Gautam G.S. Patel of Bombay High Court. So he, in a trademark dispute, had ordered some similar aspect to remove the websites and infringing material from website. So what happened, the defendants did not obey the orders of the court. So he passed contempt. He was very furious. He was very angry that he stated very clearly that these are not merely suggestions. These are court orders. If you are not going to follow these orders, you will have severe consequences. So this is not the first instance. Even if what happens in major cases, see, many of us would know that there are various infringing materials, firstly regarding the apparels. So you'll find various t-shirts with the tick mark of Nike, Under Armour logos and all. So what happens, these are very small manufacturers, these are very small traders, they do business and they do infringement, they use big marks and they manufacture their goods. When cases are filed against them and orders are passed against them, what do? They are ordered to pay hefty fines. So what they do is they take up all their manufacturing unit and they run away. They vanishes over a night. So in those cases, it is very difficult to enforce the court orders. Where you will go? So in that cases, we generally request the court for ant and pillar orders, Mareva injunctions to seize the goods. We ask the court to appoint local commissioner, and this is where the interim injunction plays a crucial role. When we file a case, we file for interim injunction on the premise that it is likely that the defendant will run away or destroy the infringing materials. So if they will destroy the infringing materials, how will we be able to claim our damages? They may run away. So these are instances which are happening in IP domain. These are inevitable because these are smaller manufacturers. So there is no way out except from trying and enforcing, being very harsh. That is true. I hope Pavan, I'm clear.
यस सर, गॉट इट सर। मेरा एक क्वेश्चन और था कि जैसे
Yeah,
मैं
please.
आईपीआर लॉज में मैं काफी इंटरेस्टेड हूँ, तो करंटली मेरा ये क्वेश्चन है कि हम कहाँ इंटर्नशिप करें, कैसे सेग्रीगेट करें एडवोकेट्स को कि जहाँ पे हमें अच्छे समझ आ सके?
I'm not a kind of big practitioner, so I'm not in a good position to give you better advices, but I would go with the advices which I had received during my law school days and even I. So internship is another thing. Firstly, you'll have to understand the bare concept. You'll have to go through the bare act. You'll have to understand the concept. So once you are well aware with the concept, you can approach anybody. Because when you go to somebody asking for internship unprepared, he may pose you questions, because this has happened to many of those who I had advised or suggested to study. So you have to be prepared. First of all, you understand the concept, and once you start learning, the doors will open. So when I got my first internship, so from there on, the doors opened for my IP domain. So you can work on the IP by way of going through the IP concept by reference books and bare act. Of course, bare act is a must. The second thing is, it depends what kind of IP you want to practice and in which area you want to practice. See, there are two areas, basically the prosecution related to the filing and transactional activities. The second is the litigation aspect, the court procedures and all. So it is up to you to decide how you want to take it, what you want to take it, what you want to take, and then after decide your internship plans accordingly. If you want to practice prosecution, you refer to those names, those advocates or lawyers or practitioners who are into prosecution. And if you want to practice litigation, try to get in touch with those litigators who are into this domain, whether patent, trademarks, designs, etc.
Thank you so much, sir. Thank you.
Thank you so much, Aman. And I see that we don't have any further questions. So I think
I'm glad.
we'll call it a close now. And I would like to thank you again for this very interesting session. I see very positive comments in the chat box as well. And we are totally looking forward to have you for more sessions on specific topics, of course, in the field of trademark, which is your core specialization. And once again, this was a really wonderful session, Aman. Thanks a lot. Thanks for taking your time to answer the questions. And yeah, we hope to see you for our further sessions as well.
No, I'm literally intrigued by the number of questions and the type of questions this audience has posed, because I have been into various webinars, the WIPO's webinar, the ENTA's webinar, the generic webinars, but I have never seen such kind of questions. So mind-boggling. Thank you so much for all these compliments and questions, of course, because I also learned.
Thanks a lot, Aman. And thanks to everyone who